But ordinarily, paragraph 7, my lord, is at page 360, placetum H. Ordinarily, a litigation is based on adjudication on the merits of the contention of the parties. Litigation should not be terminated by default, either of the plaintiff or the defendant. The cause of justice does require that, as far as possible, adjudication has to be done on merits. Also, another judgment, Mala, this is reported in 2009, volume 2 Supreme Court cases, page 692. Well, I am relying on paragraph 8 of this judgment. Yes. Paragraph 8, my lord, is at page 693, placetum H. In our opinion, whether the applicant has made out sufficient cause or not, in the application filed, the court is required to look at all the facts pleaded in the application. No doubt, the consideration of the existence of sufficient cause is the discretionary power of the court, but such discretion has to be exercised on sound principles and not on mere technicalities. The approach of the court in such matter should be to advance the cause of justice and not the cause of technicalities. As a case, as far as possible, should be decided on merits, and the party should not be deprived to get the case examined on merits. My lord, I rely on these two judgments. My lord, my suit has been dismissed for default owing to laches of my erstwhile advocate. There is no inordinate delay. It was dismissed in November 2023. I came to this court by April 2024. Mala, there is my learned friend is very vehement with regards to the order of October 9, 2023. I believe there was some inadvertent error by my learned advocate, and perhaps he has written that petitioner had appeared. That is a pure inadvertence. Nothing turns on this order because the suit was dismissed by the subsequent order when no one appeared. So perhaps this controversy with regards to October 9, 2023 order has no longer exists and has been put to rest by Justice Krishna Rao's order appearing at of 25th September 2024 at page 15. I will kindly restore my suit. I am grateful.
Yes. Normally, my lord, when there is a restoration application, my lord, we generally don't stand in the way, my lord. Normally.
So this is an exceptional case.
This is an exception.
It should be opposed.
It must be opposed.
Very well.
Why, my lord? Because there are 2-3 issues to this. One, my lord, the application whose suit may be dismissed. It may happen. It happens to everybody. Restoration applications do come. But that has to, the petitioner, my lord, has to come with clean hands. That's the, my lord, the first thing. My lord, no, my lord, statement should be made before this court on affidavit, my lord, which is false. That is, my lord, the basic principle we everybody follow. Now, my lord, when this suit was dismissed in whatever date, my lord, they came up with an application which is, my lord, J number 2. Now, my lord, when J number 2 was placed before Justice Patnaik, when Justice Patnaik had the determination, now, my lord, they had annexed an order of October 9, 2023, which appeared to be, and they had, my lord, made averments on the basis of that order, that the parties appeared in the suit, and, my lord, the parties requested the honorable judge to take up the matter on such a date. And then, my lord, that suit was posted on a different date. Instead of the suit appearing in that date in December, the suit was preponed to a date in 17 November and dismissed. That was, my lord, the pleading which was there in J number 2.
So what is your that contention? You know,
yes, I will place, my lord. I will place everything. In short, my lord, I will indicate my points in brief. After that, my lord, I will take, my lord, 5 minutes to elaborate. I will not take more than 5 to 7 minutes. That's the first thing. Second thing is, now when, my lord, Justice Patnaik released this matter because of this controversy, because the original orders were passed by Justice Rao, the matter was placed before Justice Rao. Now, Justice Rao, after having seen the petition, now what transpired, my lord, is that on October 9, 2 orders were passed. In one of them, my lord, none appeared before the Honorable Justice on 9th of October. In the other matter, a learned advocate appeared and, my lord, had sought time. Now, my lord, in that petition in GA2, all averments were made on the basis that the advocate had appeared and had sought time on 9th of October, which is, my lord, very important. Why I am harping on this point is very important. I mean, what transpires subsequently is, my lord, they are now trying to rely upon an
Where is
order
the
of.
contention in the affidavit in opposition
There were-
regarding that?
Yes, my lord. I will indicate. Now, my lord, what this order was not in any event not annexed to my the copy of the petition that was served upon me in any event. If it's there in my lord's copy, lordship will kindly take page 11. Now, this is the order, my lord, they are now trying to rely upon. Lordship will kindly take page 11 of their application. This, my lord, they admit today is the correct order, not, my lord, the other order. Now, what may I, my lord, read this order? It says, none appears on behalf of either of the parties. No accommodation is sought for. For the interest of justice, the case is adjourned. Let the matter appear on 17th November under the heading. It is made clear that if none appears on behalf of the plaintiff on the next date fixed, the suit will be dismissed. So, my lord, this was an indication that was there in the order dated 9th of October 23. And on that day, my lord, none appeared. Lordship.
The erstwhile advocate was there. So far, this order is concerned.
I will.
So not the present advocate on record.
No, my
previous
lord, there is something more to it. Lordship will
Oh,
kindly
who
take.
was the advocate on record? The present.
They say no. They say some previous advocate on record was
Is
there.
it a fact that previous advocate on record was there?
I don't know because it's their contention. Nothing has been placed on record as.
Have you disputed that?
Yes. I'll show, my lord. Lordship will kindly bear with me for some time. Lordship will kindly come to paragraph 6, page 4 of their application. It's their restoration application. They will have to cite grounds, my lord, as to why the suit has to be restored. Lordship will kindly take paragraph 6. After that, both the suits were never tried together. On 9th, has Lordship got it? On 9th October 23, which is this order, the suit being CS number such and such came up for hearing before Honorable Justice Krishna Rao, wherein on the prayer of the counsel for the plaintiff petitioner, his lordship was pleased to adjourn the suit. Where is that prayer, my lord? And where is the recording of the appearance of the advocate? They are still harping on an order, my lord, which was wrongly passed. They are still relying on the wrong order of 9th of October.
Annexure B.
Yes, my lord. That is Annexure B. Lordship will kindly take. Why I am so vociferous about, my lord, the 9th October the order is this.
That is
9th October at page 11. None appears on behalf of either of the parties.
what was the other order passed on?
That's exactly, my lord. I will come to that. What annex করা আছে?
Order to the
9th October order annex করতে বলেছিলাম সেটা কোথায়?
The other order is annexed.
Page 14 of my opposition, my lord. Yes, my lord, it's annexed.
Of your opposition.
My opposition, my lord. There is a reason, my lord, why I am so vociferous, because, my lord, they are trying to, my lord, commit a fraud on the court. My lord, had this been a simplicity restoration application, I would have never stand in the way.
I oppose to this statement. Committing a fraud. No.
Got his chance to
No.
Consider his affidavit. Where is the contention of fraud?
Absolutely, my
Yes, sir, I will show, my lord. He will also consider my reply.
definitely.
When making a statement from the bar that I have committed
Definitely.
fraud, it's a very. I do not indulge in such practices.
Yes.
My lord, I
It's a typographical error. My learned advocate on record in reply to my learned friend's condition has prayed for
Okay,
that
this is-
apology.
Okay, this is not annexed by you. Page 14.
Yes,
Yes.
my lord, they have not annexed. They have not annexed.
What turns on this?
No, I did not, my lord, object to, my lord, when my learned friend was
No,
submitting. Why is he getting
You're
excited?
you're using very strong words like fraud.
Yes.
That is
I
not
am.
proper.
Okay, then.
Now, my lord, 9th of October, lordship will kindly see at page 14.
Yes.
As per the prayer made by the counsel for the plaintiff, the case is adjourned. So, my lord, this is the order they are trying to rely upon in their avowment at paragraph 6. Lordship will kindly take note of this because the order that they have annexed of October 9, there is no appearance of any of the parties.
Anyway, but so far their annexure B is concerned, it is a different order.
It's a different order, but Lordship will kindly see the avowment they have made.
Prayer, so far annexure B is concerned,
No.
it is a different order. What you
But
have
I stand by this order. What is my learned
Yes,
friend
he
is
has to stand,
attempting-
not only stand by the order, but also his avowment. What is his avowment?
I've given a
26.
clarification in my reply, which my learned friend is very conveniently not placing before your lordship.
You know what?
I will wait for my turn. Let him exhaust himself. I will wait for my turn.
Your amendment, it was adjourned, which is the order is supported in affidavit in opposition of your learned friend.
May I indicate? May I indicate, my lord? If I will, my lord. I'm sorry to interrupt
okay,
him. Let him
give your
conclude.
reply.
I will give my reply.
Why is my lord intervening, my lord?
You complete thereafter, he will reply.
So, my lord, on what transpired, my lord, is that in his application in this restoration application, my lord, the government, he has to, my lord, justify why, my lord, the non-appearance was there. He has to make out some cogent ground. He just cannot come before the court and ask for just for the taking, my lord, that I will have my suit restored. So, my lord, his averment starts from paragraph 6. Now, what is his averment? That on 9th of October, my lord, someone appeared on behalf of the plaintiff before Justice Rao and had sought adjournment, which is, my lord, absolutely incorrect statement on oath. Because the order that he is trying to rely upon clearly records that none appeared. That's the first thing, my lord. Second, my lord, if, my lord, that is true, my lord, on 9th of October, my lord, the order that my learned friend is now trying to rely upon, my lord, it was clearly indicated by Justice Rao, my lord, that if none appears on behalf of the plaintiff on the next date fixed, the suit will be dismissed. This clear indication is already there. In spite of that, my lord, on 17 November, none appeared on behalf of, my lord, the plaintiffs herein. Now, my lord, this issue of, my lord, advocates changing, my lord, there a lot of, my lord, exceptions, my lord, has been taken by the honorable court, this honorable court, my lord, on various other matters, my lord, wherein if an aspersion is made against an advocate, my lord, that, my lord, has to be, my lord, supported by an affidavit by the said advocate. He just cannot walk away free by, my lord, making an allegation against a learned member of this bar, saying that, my lord, he has not taken steps, and that's why, my lord, suit has got
admitted position that the learned advocate did not appear. Okay, and it is an admitted position.
It's an admitted position, yes.
He did not appear.
He did.
Now,
My lord, what instruction? My lord, whether that instruction,
petitioner or the litigant will not have a hand. He may.
whether, my lord, that instruction was, yes, my lord, he will have his different own reasons to be framed.
Position.
And, my lord, on 17, this clear indication was there, my lord, in the order of October 9, my lord, that if none appears, the suit will be dismissed.
On 2 occasions, it is an admitted position. It
Yes,
did not
that's, my lord.
Not the present advocate, but the former advocate.
We don't know, my lord. Present advocate, my learned friend has already appeared, my lord, for this party in different suits. I don't know, my lord. The advocate on record might have changed. That might.
It will be available in the
Yes,
record.
it's there.
Yes, when did you obtain the change?
My learned friend, copy this is changed.
February, in the month of February, your lordship.
2024. There is a fresh wakalat now.
When the application for restoration was filed, GA2?
I didn't bring that.
A lot of things will come up, my lord. First.
Yes, please.
First. Second thing is, my lord, this is one aspect of the whole thing, my lord. The second thing is, they have, my lord,
6 January 2024, your lordship.
that.
By 6 January 2025.
देखे सुने बोल भाई.
Record.
Making submissions before the court, at least be.
This, see, your earlier, the restoration application was filed in 2024. Okay. So who was it was the former advocate or
no, no, my learned friend had filed.
Okay. But the Vokalat,
we usually, one
Mr.
Mr. Chatterjee was the advocate on record, whose name would appear on the back sheet of
Let him, my lord, come and say, my lord, or no, if
it is not required, madam. All these kind of hype, he is taking. Let him complete. I will address all his points.
Somebody who was required to appear did not appear.
Yes.
And, my lord, the second thing is, my lord, this is, my lord, one aspect of it. The other aspect, my lord, is that this application, my lord, has been taken out, affirmed, my lord. Lordship will kindly take the page of affirmation. Page 9, my lord, of their application, my lord. My lord, the applicant herein, the petitioner company, it says, it's in the name of Fairland Development Private Limited. Lordship has seen, my lord, the application has been taken out, my lord, in the name of Fairland Development Private Limited.
Yes.
My lord, an affidavit has been shown in the name of Fairland Development Private Limited. Lordship has seen, my lord, at page 9, my lord. Lordship will kindly page 9. An affidavit, this is the affidavit, my lord, by my lord, my learned friend's deponent, my lord.
Yes.
My lord, it says the application is taken out by, my lord, in the name and style of Fairland Development Private Limited. Now, my lord, this Fairland Development Private Limited ceased to exist in 2010. I will, my lord, show the certificate of incorporation. My lord, in fact, there are orders to that effect. Annex করলে ভালো হতো একটু।
No, have you annexed in your affidavit
Yes,
in
yes, my lord,
opposition?
it's there. My lord, the order is there.
Okay.
I have, my lord,
তো annexion গুলো কোথায়?
Mukherjee order.
আপনি মেলে পাঠিয়ে দিন।
Lordship will kindly take page 12.
মেলে পাঠিয়ে দিলে প্রিন্ট আউটটা করুন।
মেল নামে পাওয়া
Passed in a different suit, my lord, between the same parties. Therein, my lord, I am the plaintiff, he is the defendant. It's a subsequent suit of same year, my lord.
Yes.
My lord, in that suit, in 20, my lord, I had taken out an application in 2020, my lord, or 2019 actually, for, my lord, change of name of the defendant therein, who is the plaintiff herein.
Yes.
And, my lord, this order was passed therein by Justice Mukherjee. What transpires from this order is that, my lord, the company being Fairland Development Private Limited has ceased to exist on 14th of September 2010. May I hand over a copy, my lord, of the, my lord, the two certificate of incorporations?
No, why have you not annexed this?
We have crave leave, my lord. We have crave leave in the opposition. We have crave leave, my lord. Lordship will kindly take my opposition. I have crave leave.
You give a copy. to your-
Page, yes, my lord, please. Page, my lord, 3, my lord, paragraph, my lord. কোথায় কোন প্যারাটা? Paragraph E, my lord, I have crave leave, my lord.
Yes.
This, my lord, are the two certificate of incorporations. Lordship will kindly, my lord, have a look. কবি লাগবে তো?
হ্যাঁ দাও, দিলে সুবিধা।
নিজের কোম্পানি নিজে জানিস না?
রেস্টোরেশনে ভাই
Lordship will kindly see. This actually was, my lord, annexed to, my lord, the petition, my lord, in which, my lord, Justice Mukherjee has passed the order. Lordship will kindly see. I hereby certify that Fairland Development Private Limited, which was originally incorporated on 14th of such and such, under the companies as Fairland Development Private Limited. Then, my lord, Lordship has found it. Then, my lord, Lordship will see the next certificate of incorporation, my lord, within a few days, my lord. This Fairland Development India Private Limited, my lord, came to known as, my lord, Fairland Development India Private Limited. So, my lord, this application, my lord, as on today, cannot be affirmed, my lord, in the name of, my lord, Fairland Development Private Limited. It cannot be. It's a wrong affirmation, my lord. In 2010, my lord, the name of their company had changed. They waited for 13 years for, my lord, the suit to be dismissed.
In the
I
meantime,
had taken out the application,
no.
order is there.
all these the proceedings, interlocutory applications were.
Yes,
continuing in
everything
this
was everything was continuing.
Everything was continuing
No,
in this court.
not in his suit, not in his suit, not in his suit, my lord, not in his suit. That is
What
the
was
thing.
the stage of this suit?
Yes, my lord. There were, may I come back, my lord? There are two suits. One, my lord, filed by him against me, one by me, my lord, against him. Now, my lord, my suit was continuing in that suit, my lord. Justice Banerjee had passed an order because they said that, my lord, they have to, my lord, both the suits to be tried together. They, my lord, never took any steps, my lord, for the suits to be tried together. In fact, my lord, since 2010, they have not taken any step in their suit so that, my lord, even the name can be changed. We, my lord, did take the step in 2020, the order I have annexed. When, my lord, we came to know about the change of name of, my lord, the plaintiff herein, who was the defendant in my suit, my lord, we have taken out an application, my lord, wherein our order for amendment was allowed by Justice Mukherjee in 2020. I have annexed that order, my lord. Page, my lord.
Yes, I've gone through that.
Page 12, my lord.
Yes.
So, my lord, standing today, probably, my lord, this application before your lordship is filed in the name of an entity, my lord, which is a nullity before this, my lord, before this court. It cannot be affirmed, cannot be filed. My lordship will kindly, I will, my lord, plead before your lordship to check, my lord, as to in whose name, my lord, the affidavit of competency has been filed before this court. My lord, an affidavit of competency, my lord, cannot be affirmed today, standing today, my lord, in 23 or 24, my lord, in the name of Fairland Development Private Limited. It cannot be, my lord. This entity is not there.
Yes, that's all.
This and, my lord, one more thing, my lord. They say, my lord, they had taken inspection, my lord, in February, my lord, 24. They say that, my lord, the erstwhile advocate on record, my lord, did not take steps. So, my lord, for 13 years, there was no instruction from the, my lord, the client. All of a sudden, in 3 months, an instruction came, a change of advocate came. My lord, once the suit is dismissed, and my lord, they took inspection before of, my lord, the original case records, because the original case records was lost no, by the previous advocate on record. No, my lord, document, my lord, has been, my lord, disclosed in this, my lord, application to show, my lord, they had taken, if they have taken inspection, they just cannot go before the original site, my lord, record department, and, my lord, take inspection. They will have to apply for it, and, my lord, it's allowed. But this is the process, my lord, lordship knows. It has to be, my lord, applied before the, my lord, the registrar, my lord, and, my lord, it has to be taken on a specific date, my lord, after, my lord, officially, my lord, applying for it. Nothing has been, my lord, disclosed on record to show, my lord, that they had taken the inspection. My lord, that's all, my lord. I will plead, my lord, that this is a restoration application, yes, but, my lord, the petitioner herein, my lord, has not come with clean hands. My lord, they have tried to, my lord, first commit fraud by annexing a wrong order. Now, my lord, when that was, my lord, pointed out, they, my lord, have now tried to annex an order, my lord, but in the pleading, they have still relied on the previous order. That's the first. Second thing. Third, my lord, this application itself cannot be filed today, because, my lord, this entity is not there. If lordship, my lord, is entertaining this application, lordship will have to know, my lord, whether the petitioner is actually there. It's a company. It's not an individual that it will be alive. The person is alive, dead. It's an company. Whether it's there, my lord, standing today, lordship will have to assess. First, and, my lord, obviously, my lord, they say a lot of aspersion has been made on the previous advocate. Not that I, my lord, leave it to lordship, whether, my lord, lordship will allow such aspersions to be made, and, my lord, against a member of the bar. That's my lord. That's all.
Yes, what do you reply?
Yes. Well, I've been practicing for 17 years. I never argued a restoration application for this long.
No, regarding the change of the entity.
Entity.
What-
My lord, kindly sees the affirmation
What is
on,
the
of my
stand?
application. My lord, I cannot. My lord, suit was dismissed for default. I cannot take any steps unless my suit is restored. Kindly sees my affidavit.
Yes, page 9.
Page 9. Kindly sees paragraph 2.
Yes.
The petitioner is a company within the meaning of the Companies Act 1956 and used to formerly operates its business under the name and style of Fairland Development Private Limited, now known as Fairland Development India Limited. So I've disclosed it in my affidavit. So where is the question of it being affirmed in the name of? I cannot change the cost title. Your lordship is aware of that. This is one. And my learned friends, I again say vehemence on that 9th October 2023 order is perhaps misplaced, because nothing turns on that order. Your lordship will see the servers even today.
This wrong order. Sorry.
Please have your seat.
Sorry.
Even on the servers till today, still two orders are there.
Whatever is there in the record, that
It is there in the no.
Same order. Don't mix assumptions. Download kore dekh.
whatever is there, I shall
Cost
consider
order
in the
type
record.
wrong order.
Hey, Baba.
তুমি দেখো
Anyway,
Cost
during
order
this
type are wrong.
period, when this dismissal and all these things, you were not in the picture. I think the
Yes. The confusion is because someone else had entered appearance, and nothing turns on. And my learned friend did not show. Yes, my learned friend, by placing paragraph 6, he is saying that I am still relying on the wrong order. That is a typographical error. My kindly takes my reply. My learned friend in paragraph 3N of his opposition has made this allegation that I have made a false statement on oath by relying on that particular order. Paragraph 10 of my reply is at page 4.
Yes.
Yes. Save and accept what matters of record. Well, kindly comes to the denial portion. I deny and dispute that a petitioner intentionally has made any false averment in the present application as alleged or at all. In this regard, the answering petitioner submits that the averments made in paragraph 6 of the present application is a typographical error, and for such should not be I. The petitioner unconditionally apologizes before this court. Well, he literally, while drafting, he put himself his person. Anyways, I unconditionally apologize before this court, but it's a typographical error. A mere copy paste error. I believe he copied from the first application, which he should not have done. So it is not a false statement because I have ultimately annexed the order which records non-appearance.
Admitted position.
Admit and my on all things said and done, my lord, both parties are required to appear when a suit is called out. Even my learned friend chose not to appear.
No, it is an admitted position.
Yes,
There was no appearance.
no appearance, and nothing turns on this order. But to use words like fraud are perhaps a bit too harsh.
Yes, please take down.
I'm grateful.
Learned petitioner and learned advocate. Learned petitioner plaintiff and learned advocate for the opposite party. The respondent are present, are learned advocates on the application for restoration. This is GA3. GA3 of 2024. Hearing is concluded. Let the matter appear for orders on 29/4/2025. যেগুলো না হচ্ছে দেখাতে ফর অর্ডার হচ্ছে ওই ফাইলগুলোকে একটু আমার চেম্বারে যেগুলো ফর অর্ডার হচ্ছে এখন এটা নিয়ে কিন্তু 4টে হলো ফর অর্ডার। এই ফাইলগুলো আমাকে আজকালের মধ্যে আমাকে সবই নেক্সট উইকে ফাইলগুলো একটু পাঠিয়ে দিন না, এটা ফর অর্ডার। Yes, 29/4 for orders.
I'm grateful. I'm grateful.
Item number 16, Sri Shyamol Kumar Dasdev and others.
Your Lordship, I am appearing on behalf of the dependents petitioner, Your Lordship. Your Lordship, this application is in a partition suit. Perhaps আমাদের এটা দাও reply-টা. Your Lordship, the affidavits have already been exchanged. May I file the affidavit in reply, Your Lordship? It has already been served upon the plaintiff respondent, Your Lordship. Your Lordship, in this partition suit, final decree has been passed. Shares declared. I will come to the documents. Your
Preliminary decree passed, shares.
final decree passed.
By the-
Final decree passed by this honorable court. The shares declared in the preliminary decree and also in the final decree. Your Lordship,
Shares have been given effect to. By
Your
metes
Lordship,
and bounds.
now Your Lordship, why this application? This application is with regard to one of the properties which the advocate commissioner appointed by this honorable court had in his report stated that this property cannot be partitioned by metes and bounds. And I'll show the order of this honorable court that the report had been accepted by both parties and none of the parties have raised any objection.
So far a particular, one of the properties.
One property
Could not
Now-
be partitioned.
cannot be partitioned by metes
The
and bounds.
properties are partitioned by metes.
Those are not subject matter of this application, Your Lordship. I am considering only one property at AJC Bose Road which cannot be partitioned by metes and bounds.
Observation, what is that?
Your Lordship, may I draw Your Lordship's attention to page 30, Your Lordship. This is the report of the Advocate Commissioner, Your Lordship. It starts at page 27. Page 27. And the specific
Yes,
paragraph is at page
27.
30. 27, the report starts.
Yes.
Your Lordship kindly comes to page 30 straight away because there is that observation which I'm relying upon. The second paragraph, if I may please. And regarding the other property at 109 AJC Acharya Jagadish Chandra Bose Road, Kolkata 14, it is stated by the surveyor, Mr. Banerjee, that the said building is only one-storied, containing one big room with wooden board partitions and a small room used by the plaintiff as a diagnostic center. The surveyor clearly stated in his report that the said property cannot be partitioned, and the only option is to sell the property and pay the amount to the parties as per their shares. The survey report is filed before the commissioner. Now, your lordship kindly turns over to the next page, your lordship, page 31. Honorable Justice Rao's order of 4th July 2023. না এটা কোথায় গেল ওই অর্ডারটা that মানে your lordship by way of this order the final decree was passed না এরা না হ্যাঁ your lordship I will only place one more order in this regard. Your lordship kindly comes to page 18.
80. No,
18.
18.
Your lordship,
Yes.
this report is dated 21st July 2023, and
7th
this
August 2023.
your lordship the advocate commissioner's report is of 21st July,
Yes.
and this order is of 7th August. Your lordship kindly comes to the third paragraph. Counsel for the respective parties submit that they have no objection for acceptance of the report submitted by the learned commissioner. In view of the submission made by the counsel for the respective parties, the report submitted is accepted. And your lordship, accordingly, prayer B of GA 20 of 2023 is allowed. Now, your lordship, the final decree has been passed. The advocate commissioner's report that this property is impartable has been accepted by all parties. Now I'm coming before your lordships.
Yes, buddy.
Now I'm coming before your lordships only for the sale of this property.
So by 7th August 2023, anyway, there
Yes,
was
sir.
direction to draw up the final decree.
Yes, your lordship.
In terms of the commissioner's report.
Yes. So the shares are admitted. There cannot be any dispute to the shares. The property is impartable. That also stands admitted.
One of the properties.
One of the properties, the 109 AJC Bose Road. Now I am only seeking in this application for the sale of that property, premises number 109 AJC Bose Road. Nothing else, your lordship.
The final decree is drawn up and complete.
The final decree is yet to be drawn up in process. But your lordship, there is no impediment since the preliminary decree has been passed, the report has been admitted because nothing can be done. It's an impartable property, your lordship. The only way is to sell out the property.
Yes, under
So
what
that-
provisions you took out? Actually, the suit is, I think after drawing up the final decree, the
Now,
suit is
your
treated as
lordship-
disposed.
Treated as disposed, but your lordship kindly considers in the
Under what
preliminary
condition?
decree, the shares will stand admitted. Now, as soon as the shares are admitted, the next venture which the parties have to get into is whether any of the properties is partable or impartable, because that is the crux of the partition suit.
What is partable, that is done.
That will abide by the final decree. That is different, your lordship. But one property which is impartable, as observed by the advocate commissioner, not objected by any of the parties to the suit, and hence that report
That
is also
remains to be disposed of.
that remains to be disposed of, because your lordship,
Or the sharers will continue with that shares.
your lordship, that has to be disposed of, because for realization,
If it is impartable, two options. Either it will remain as it is, or it has to be disposed of.
yes. Now, your lordship, the only thing which can be if it has to remain as it is,
Yes, sometimes
then-
parties can dispose that property, or sometimes it is to be done by the intervention of the court.
but yes, your lordship,
If parties can amicably sell that property, well and good.
yes, your lordship.
Otherwise, it has to be done by the intervention.
Grateful, your lordship. Now, your lordship, no amicably, there is no question of any amicably an amicable resolution in this case. So I am seeking a fair way out by way of auction sale, by order of this honorable court, and nothing more. And whatever
you
the
say?
proceeds are, before my learned friends start, the before by way of the sale, whatever comes in, let it be deposited with this court. And thereafter, when the time comes for the
Anyway,
dispute.
receiver has to be special officer has to be appointed.
Yes, yes, your lordship.
And he has
Only.
to conduct, he has to collect the
Yes, your lordship.
receipts and
I
to-
am not saying
and
that
to
I
deposit in court.
absolutely by bow down to your lordship. I am not seeking for any order that I'll be allowed or my learned friend's client will be allowed. Let there be an officer of this court who will conduct the process. And there cannot be any impediment if unless my learned friend shows that the shares are not admitted, the advocate commissioner's report is not accepted, which
Is there
is
any
admitted.
appeal against the preliminary decree?
No appeal. No appeal, your lordship.
Final decree.
This is the only pending application, your lordship.
What is the valuation you have in?
Your lordship, we have obtained a valuation.
You have intimated them.
We have intimated them also. The valuation as on June 2024, it's standing at 1.15 crores.
1.19.
An area of
One kata, one chitak, 5 square feet.
is 1 point, no, it is a one flat.
No.
It's one storied building, your lordship, with land. It's a single storied building,
1.5 crore.
1.15.
No.
1
It-
point-
This is the value.
Oh, I apologize, your lordship. 1.19 crores.
1 crore 19 lakhs.
1
Yes,
crore. nine-
what is your submission?
My lord, at first, I want your lordship attention towards my affidavit filed in the court. In page 10 of my affidavit in opposition.
Yes, page,
10,
yes, what is the opposition? Opposition to the
page 10. Yes. My lord, Honorable Justice Krishna Rao has passed the final decree in which I am appearing on behalf of my client, plaintiffs, and therein the Krishna Rao, Justice Krishna Rao passed the decree, final decree, and made collector of custom to for education of the stamp duty. But my learned friend's client is not willing to pay the stamp duty on the decree. Decree has been drawn up, completed, and sent before the collectorate of custom for education of stamp duty.
Oh, unless the stamp duties are paid, the process will not be completed.
Yes, my lord.
The process, for the completion of the process, that is required to be paid.
Yes, my lord.
So this is the latches on their.
Well, they are all the part of defendants, my lord. And para 11, page 11, my lord, just to see my position. My learned friend made an application for renovation.
11.
Page 11, page 11, application for renovation. That application has been heard and dismissed.
That is
By
a
the
different
Krishna Rao.
property, your lordship.
Maybe.
There is a partition.
Nothing to do with this property.
No, you see, ultimately, unless the stamp duties are paid, okay, the entire process will not be complete. They are bound to do that, okay?
Yes, yes.
Either today or tomorrow.
Yes, my lord.
But pending that, if the property is sold out, what is your difficulty?
I have 1/4. Learned friend has 3/4. I have no
So you don't have any
I have no,
difficulty.
nothing.
So a direction can be issued to comply that as well as
My lord.
necessary appointment direction to comply that of degree as well as
The stamp duty, yes, is
Yes.
concerned.
and in the meantime, let somebody be appointed to cause sale of that property, that portion.
Yes, my lord. That is portion of property in question.
No, but question
No.
is, you see, entire stamp duty is also with regard to the property which you are going to sell.
No.
Okay,
None.
so let that be complete.
Your lordship,
Unless it is complete.
if I may apprise, your lordship, in order to sell a joint property, your lordship, two things are essential. One is as to my understanding, your lordship, one is the shares. My learned friend submitted that it's admitted we are the 3/4 owner and the plaintiff is the 1/4 owner. So that goes out of the question. Secondly, the property is impartable. admitted position.
সেটার জন্য
Now, your
এটা
lordship,
attracted.
No, but there is
now
no
your lordship, I
compliance.
am coming to that.
Compliance of the
I
sovereign
am
decree.
coming to that, your lordship. Now, your lordship, there is no impediment for sale of the property per se.
ওটা তুমি
There can, at best, there can be an impediment in realization the sale proceeds by the parties. Which is why, your lordship, at this juncture, I am only seeking
Now,
that let the
now
property
the
be sold out.
question is, if this, you see, what is this? The stamp duty of the said decree,
Yes.
okay?
এটা পার্টিশন যেটা যে
This is
সেটার
to
উপরে
be
কিন্তু
paid. And thereafter, I think
সেটার
this is
উপরে।
to be registered also.
Your,
No,
your
that is
lordship,
only
this stamp duty is only on the partable property.
নট অন দিস
No, no,
Not on this.
property.
নো
No,
এটা তো আমরা আলাদা করে
And-
part দেবই স্ট্যাম্প
And your lordship,
Intersuit property.
in the suit property, yes, my lord.
that should, the other property which my learned friend was trying to bring up in this application.
Let us, the
No.
decree is
But
with regard to the suit
Perhaps,
property.
perhaps your lordship, at this juncture, we need not delve into this thing. Why I am submitting this? Because your lordship kindly considers what I am submitting is for appointment of a special officer, for sale of the only property which is impartable, and depositing the sale proceeds with this honorable court.
Now,
Because
now
at
what
the
will
end,
have now, so far the decree is concerned, you see,
now your
stamp duty of the decree
Yes,
has to remain
now,
unaltered.
all I'm trying to submit is I understand what has fallen from your lordship.
No, stamp duty is unaltered.
Absolutely. Your lordship, firstly, I'm not going into addressing whether that stamp duty is for all the suit properties or the only portable property. Because now your lordship kindly says for sale of the suit property, the final decree is not unnecessary, not essential. Because only the preliminary decree which states declares the shares of the property, which is admitted in any case here, and that it is impartable.
It's better you
No-
can do one thing.
Now
You
your lordship,
apply this portion.
now
and
your
come.
lordship kindly allows me to address,
Yes,
kindly
yes.
allows me to address. Now, when the proceeds come in from the sale of this property, that is lying with the court. Thereafter, we can always make an application before the court for appropriation of the stamp duty from the sale proceeds. And then only the parties will be able to.
Difficulty, you just pay and then you.
Your
come
lordship
after 1
kindly
week or 2 weeks.
kindly envisages this situation. What will happen is this: if your lordship allows this thing, now they will try to object and get it lingered on.
No,
Because
no.
I cannot, I am
I
not
shall
supposed.
record your submission.
No,
that-
no, your lordship
that
kindly
is
allows me.
My lord, that might pay
Your lordship,
then of applicable
not
position.
Yeah, record of consent. That
your lordship, there is no
The
harm in doing that.
The collector has assessed the stamp duty of the critical amount. That is
I
2
will
lakhs.
very well, your lordship. If your lordship is delving into that question, whether it's with regard to this property or only the
No, no,
What
no.
property? That is
your
what
lordship
property.
allows me to come back. Kindly come, allows me to come back tomorrow. I will clear that confusion. Because my learned friend is now trying to bring up these things only to linger the sale of the property.
Not looking at the sale of
Absolutely,
Shall
your
you come
lordship.
ready or
My
shall I
lordship
keep
is
it day
law.
after tomorrow?
Your lordship,
But by I
Come ready tomorrow or shall I keep it day after tomorrow?
day after
Okay, bolo.
tomorrow, my lord. Day after tomorrow.
day after tomorrow, let it be.
Okay.
Day after tomorrow.
Learned advocates for the parties are present, are learned advocates. As hearing could not be concluded, let this matter Yes, all the Jalpaiguri matters.
Lord, Lordship,
Lordship, item number 1, I am appearing on behalf of the petitioner.
Yes, the petitioner be released on bail with two sureties of rupees 10,000 each, one of which must be local, subject to the satisfaction of learned trial court. The petitioner, upon being released, shall comply the following conditions. Yes.
Grateful, Lordship.
Item number 2. Yes, item number 2, you are appearing.
No, Lordship, I am not in item number 2, Lordship.
Yes, item number 2, hence the petitioner be released on bail with two sureties of rupees 10,000 each, one of which must be local, subject to the satisfaction of learned trial court. The petitioner, upon being released, shall comply the following conditions. কেউ ছিল না। ঠিক আছে, এটা তো আপলোড করে প্রিন্ট আউট করে তারপর ইয়ে করতে তারপর হয়ে যাবে। আজকে পাঠাতে পারলে ভালো, নইলে সকালবেলা কাল পাঠাবো।
Lordship, may I be permitted to mention a specially assigned matter, Lordship, on the appellate side. The interim order passed by your Lordship on 17th of March 2025 is due to
It will
expire.
appear on Friday.
Lordship, grateful. I'll inform the other side, Lordship. Gratefully, Lordship. Orderটাও দেওয়া আছে।
original size matter, old suits item number 17, Devi Rani Nandi,
Let's pass it over.
17. My lord, একটু প্রত্যেকটা seat। Eighteen, Tascon Engineers Private Limited, 19, Shambhunath Nandi, 20, Rekhahori Sarkar, 21, Bilaspur Casting Limited, 22, Probit Choudhury, 23, Jitendra Umabhari Patel, 24, Srimati Jharna Mallik, 25, Ranjit Kumar Das, alias R.K. Das, 26, Graphite India Limited, 27, Vishwanath Kalanoria, 28, Anubha Pal, 29, National Insurance Company Limited, 30, Somnath Estates Private Limited, 31, Unisilk Limited, 32, Unisilk Limited, 33, Ashok Kumar Sen, 34, Rajnish Tiwari, 35, United India Insurance Company Limited, 36, Deep Narayan Mitra, 37, Amit Basu, 38, Star Trek International Limited, 39, Polar Fans Industries, 40, Rashtriya Ispat Nigam, 41, Rashtriya Ispat Nigam Limited, 42, Kumari Moon Roy, 43, Garden Reach 44, সমীর ব্যানার্জি 45, রাষ্ট্রীয় ইস্পাত নিগম 46, শারদা জেমস লিমিটেড 47, নওয়াল কিশোর চৌধুরী 48, অঞ্জনা খাকারিয়া 49, মিসেস ত্রিমূর্তি কার্গো 50, স্টেট ব্যাংক অফ ইন্ডিয়া। এটা একটা সেকেন্ড কল করে দিই না, পর হিয়ারিং ও ডেকে দেব।
ওর হিয়ারিং গুলো ডাকুন
আচ্ছা, for hearing item number 51, Manish Agarwala.
Lordship, I appear for the petition. I am led by Mr. Devdut Mukherjee. Lordship, this is my application, Lordship, for setting aside of the report of the special referee, Lordship.
The opposite party is not here. So it will be
Lordship.
passed over for the first call.
52, Turner Morrison 53, APJ Private Limited 54, APJ Private 55, APJ Private 56, SK Surana 50,
And for the degree holder,
Item.
56, led by Borun Kothari.
So what is this application? GA1?
GA1 is the third party application,
Yes,
my lord.
third party application. Yes, second call of the hearing matters.
second call of hearing matters item number 51, Manish Agarwala and others.
Lordship, this is my application, Lordship, for setting aside of the report of the special referee, Lordship. This is a matter, Lordship, where decree has already been passed way back in
Affidavits are complete.
Lordship, the affidavits are complete, Your Lordship. Lordship, we had informed the other side also that the matter. Lordship, I'm led by Mr. Devdut Mukherjee.
My lord, this is my application, my lord. We are coming before the court for the third time. My lord, suit was filed for, my lord, eviction and mean profit.
So
Eviction.
the defendants are, the tenants are vacated.
Yes, they have vacated, they have handed over possession. The only issue which is remaining today,
Profit,
mean profit, my lord. Mean profit was assessed thrice. All the three times it was challenged, my lord. It was set aside, my lord, and direction was given to freshly assess the mean profit. Now, today, my lord, we have come here for the last time. We do not want to go back, whatever your lordship feels and decides, my lord, because we have been kept, we have not received the money for a long time.
How much amount is assessed?
My lord, I'll just indicate. আমাকে volume two এটা আমরা চ্যালেঞ্জ করেছি তো এটা তোর ইন্ডেক্সটা বার কর ইন্ডেক্সটা আছে বল লাস্ট যেটা রয়েছে লাস্ট যেটা মেইন প্রফিটটা কোথায় বল না কোথায় সেটা দেখা copy of the report filed by my lord will kindly take volume 3 my lord your other side to nahi page number Kindly cease, my lord, page 0402.
For my learned friend starts, my lord, I am for Steel Authority of India Limited in this matter, my lord.
You are for?
First, defend Steel Authority of India Limited in this matter, my lord. Now, my lord, I have twofold prayer. First of all, my lord, the copy of application I do not have. I've been recently appointed in this matter. I do not have the copy of the application. I don't know whether it was served or not earlier. Firstly, that matter, and my lord, may I be granted the leave to file wakalatnama in this matter because, my lord, because
Affidavits are not filed. in
no, my
this
lord,
I
the
believe affidavits were exchanged, my lord. I'll just indicate. Take out.
I do not have any instruction to that effect, my lord. First of all, this is an old matter, and I've been recently appointed in this matter, my lord.
My lord, the earlier advocate on record, Mr. S.N. Sen and B.M. Law and Company, my lord, had given us the affidavit in opposition, my lord, which was affirmed on.
So you have also filed your reply.
Yes, my lord. A reply is also filed. Acha, to record opposition.
Serve a copy upon your learned friend. Let him take
My lord, may I?
instructions, because he is newly appointed in this matter.
My lord, only one thing, my lord. I will be fair before your lordship, my lord. The copies, since I see the oppositions have already been filed, I will be photocopying it at my cost, my lord. Because since
He'll take application. I believe he does not have the opposition as well.
Opposition and reply,
the reply also.
So as well as the reply.
Reply.
As well as the reply.
I will do it at my cost, because my lord, since I cannot oppose that, because since I see that all things are exchanged, my lord. And my lord, may I have the leave to file the wakalat now, my lord?
Record an order.
Leave করে দিন না যাচ্ছে।
Learned advocate for the petitioner degree holder and learned advocate for the defendant judgment debtor are present. Learned advocate prays for time to seek necessary instruction in this matter as he is newly engaged. Such prayer is allowed. So I am not recording any order that you have served a copy.
My lord, may direct me. I will give. There's
An informal.
My lord, kindly records an order, because my lord, since the cost has also
My lord,
come
records
from
an order because this is sale.
this sale, my
Without
lord.
my lord's order,
Without my lord's
perhaps.
order, I cannot realize the cost, my lord.
Copy of the learned advocate for the petitioner decree holder is requested to serve copy of the application, affidavit in opposition, as well as and reply upon learned advocate for the opposite party judgment debtor at the cost of the judgment debtor. Let this matter appear for further hearing on. Yes, how soon can you take your
My
instruction?
lord, 3 weeks time, my lord.
Let this matter appear on.
My lord, let it be 2 weeks, I'm saying, because otherwise the
My lord,
vacation would begin, my lord.
the only
And
thing
we have
is
been
that-
waiting for a long time for this, my lord, since
the
2009
only thing
suit.
is that only impediment is that, my lord, that I cannot gather the instructions, because I know nothing about this matter. I have the plaint and all things of this matter.
Let this matter appear on 13/5/2025 at 2 p.m.
I'm extremely grateful to my lord. I'm extremely grateful. Sure. Thank you. Now we're done.
Item number 52, Turner Morrison Limited.
May it please your lordship. This is my application. This is the same matter, my lord, which was taken up on the last day when my learned friends wanted time. This is, my lord, we had filed this application taking exception to a report filed by the commissioner. We've taken our points here as to why the report filed by the commissioner cannot be sustained. We have also filed an affidavit taking that exception, but since the point was taken up that it cannot be done through an affidavit, to put that issue to rest, we file this application. If my learned friends want to file an affidavit, I do not know what the instruction is, but then we can proceed.
This is your exception in the form of an application.
It's my exception in the form of an application. That's a short point.
That is GA9.
That's GA9.
It's an
And my
exception in the form of an application to the commissioner.
to the commissioner's report, indicating as to why that report cannot be sustained.
Let him contest that. For that
Indeed.
he has to file an affidavit.
Indeed.
Short affidavit, my lord. 2 weeks.
May I only make a prayer, which is an innocuous prayer? It's a checkered history that this matter has. There are some suits filed by my learned friends' clients, some by my clients. My prayer is that there's one suit CS11, which I'm praying if that can be tagged with this proceeding. It's the same prayer, same property. The issue in brief, I'll indicate what the issue is.
As far as that
Is
is
it necessary
concerned,
for consideration of the commissioner's report?
Yes, because there's a division bench order where it was indicated that the proceedings should be heard analogously, which is not been tagged. The moment this is tagged, my suit is prior in point of time. So if this is tagged together, it can be taken up. Whenever it is taken up, it can be heard together.
my lord,
That's
may
the only prayer. I do not. I'm sure my learned friend will not have an
Even if
objection
it
to
does
that.
not appear also, your application can be heard out.
My application can be heard out. It is CS 11 of
let me file an
2013.
affidavit to his application. Let it turn up, then my lord, your lordship will consider if your lordship.
May I only make this prayer that if this is only indicated in the list, because today if CS 11 of 2013, which is prior in point of time with regard to the same suit, if it can be tagged along, I'm not praying for any other relief.
But all I'm saying is,
It's
let
all
us
that I'm
file the
praying for.
affidavit. If after hearing, my lord, if your lordship feels that it don't have to be
No,
tagged,
it has nothing to do really with the.
Division bench order, then
It's a division bench order.
that has to be heard out.
but
I'm
that-
only
that
praying.
is all-
I'm
all-
only praying that this be tagged along
my lord,
together.
I will be able to satisfy your lordship that his application can be taken up on a standalone basis. Your lordship hears the matter, and
No, I'm
if
not.
your lordship wants, your lordship can tag it.
My lord,
Do not tag it right now.
I do not have any.
For the petitioner defendant and learned advocate for the plaintiff opposite party are present. Learned advocate for the plaintiff opposite party intends to use an affidavit to the application of the petitioner defendant in GA 9 of 2024. Thus, the affidavit in opposition be filed by 1 week.
2 weeks. Only gives us 2 weeks.
6/5/2024. The 25. Reply, if any, by 13/5/2025. Let this matter appear for further hearing on 14/5/2025.
May it be recorded, my lord, that
Let
My lord, kindly do not tag it. Your lordship, here us.
I do not.
I have many submissions to
May I only indicate this? May I only
let CS
CS 11 of 2013, my lord.
CS 11 of
My
2013
lord, they
also appear. On
I'm very
the-
grateful. That's all.
I'm just going to
also
let you
appear.
know.
My lord, do
No,
not,
no,
my lord, tag
It also appear, my
Do
lord.
not tag.
Also appear on the set date.
I'm very grateful. I'm very grateful.
He wants to challenge a report in this suit.
No, I
He has
agree.
to stand on his leg.
Application can be heard out.
Yes, on his
Indeed,
legs.
But with
Lord,
regard
may
to the
I-
main hearing, the division bench order.
I am
is
very
there.
grateful. And may I also indicate, instead of, my lord, what my learned senior friend is saying is absolutely correct. GA 9 can be decided on a standalone basis, but kindly see GA 9 is, my lord, a connected application with CS 45 of 2013. It's an application, of course, with this. So that is the reason I'm saying, my lord, this suit and the other suit, which is
May
prior
I
in
put
point
a
of time,
question to myself? Are
be
the suits
tagged
being heard
together.
out? The
Yes.
suits are not being heard out.
but this
But an
has to be
application of
tagged
one
together.
suit-
That's all I'm praying.
By the affidavits, I shall consider.
My lord, I'm very grateful. I'm very grateful.
Your lordship has only directed the matter to
Yes,
appear,
matter
not
to appear
tagged
on
it.
that. No, no.
Yes, but matter will appear on that date
Yes,
along
yes,
with this.
matter will
I'm
appear
very
on that.
grateful.
As
Very grateful.
120th.
Item number 53, APJ Private Limited.
My lord, item numbers 53, 54, and 55, my lord, these are all connected matters, my lord. I am here for the plaintiff, my lord. I was only praying, my lord, these matters could stand over till next week, my lord.
Okay, not this week.
I'm grateful.
56, SK Surana.
My lord, I appear. Your lordship, just for a moment, Mr. My lord,
My lord.
I appear on behalf of the judgment debtor. If your lordship, I have mentioned this matter.
Only.
If your lordship recalls that there was a warrant of arrest issued, my lord, thereafter we preferred an appeal against that order. Pursuant to that order, the judgment debtor was directed to be present on 27th of March before this court. He was present in this court. The order dated 27th of March dispensed with my personal appearance of the judgment debtor.
Yes.
But further in the last line directed the judgment debtor to be present. Your lordship on the last occasion.
I clarified that on
Yes,
April
your lordship.
17.
My lord, I am for the degree holder led by Borun Kotari.
I'm
It is he is not here. I prefer not today, my lord.
He's here.
Okay, not
My lord,
today.
may I?
Submission bolo
No,
na.
you are leading him in this matter.
No, my lord, I am the intervener.
Oh, intervener.
My lord,
But
I'll
you are,
tell
you are for the degree holder.
Degree holder for
Okay, you are praying for today, one day adjournment.
1 day
No,
adjournment.
আপনি
not
টাকা
today.
দিচ্ছিলেন, জমা দিচ্ছিলেন তো,
Not
সেটা করেই দাও।
My lord, Lordship, may I just indicate one thing? My lord, can it be kept after 2 weeks? Because I have instruction that my client would like to pay it off. So, my lord, I don't have the written instruction on this. So, I'm just humbly requesting if this matter can be kept after 2 weeks. Then I will be out of the picture. Then let the decree hold.
Come tomorrow, okay? He is praying for time. Take instructions, come tomorrow.
হ্যাঁ, কালকে।
My lord,
Yes, tomorrow if necessary, I shall adjourn it.
Today, your lordship is not passing any order.
No, I just made it not today.
Great.
আচ্ছা, arguments টা আগে ডাকুন, তারপর
For argument, item number 57, Supriya Khatun.
This is appearing
I
wrongly.
appear for the
I appear for the
plaintiff.
Sorry, I appear for the defendant. I'm so sorry, Lordship.
In this matter, what has happened, my lord, the witness action is over. The defendant, they were supposed to start their argument. But, my lord, they have taken out an application, which is GA10 of 2025. Lordship, that application is for, Lordship, taking out one of the documents which had already been exhibited from the list of exhibits, because it is the contention of the defendant that that is an unstamped document, but that has already been marked exhibit. So that's why they have filed an application.
That is the core document, Lordship, on which the entire suit rests.
documents of the defendant.
Lordship, it
Document
was
of plaintiff, Lordship,
plaintiff and the defendant both are relying on that document.
so if they are relying, I don't know why they want to take out the document from the exhibits.
This application has to be disposed of.
Lordship, that is why, my lord, that has been made returnable on 23rd April.
Lordship,
It is wrongly appearing today.
today.
Let it be not today then.
Lordship keeps it,
Lordship, it can be kept the next
Lordship,
week
day after tomorrow or
or next week, Lordship.
next week, my lord.
Arguing
Lordship,
that
this has been going on for quite some time, my lord.
For the plaintiff.
Lordship.
application is taken out by the defendant.
Yes, a frivolous application.
Not this week. Or not.
Lordship keeps it this Friday, my lord.
I'll be in some difficulty, Lordship.
Friday.
Friday.
The difficulties will never end, my lord, for a lawyer.
Next week, Lordship will keep any day.
Okay, not this week.
Next দিন সোমবার কি ডেট পড়ছে? মান্থলি ডে না তো?
No, monthly listening.
Monday, my lord, in that case, my lord.
Deeply obliged.
উইটনেস সেকশন কল করুন, দেখি কিরকম কতজন টার্ন আপ করেছে।
Sections, item number 58, Gobindo Ghosh.
Lordship, witness is here. Continue.
Witness is here. You are for the?
I'm for the plaintiff.
You are for plaintiff?
Yes.
Okay. The other side?
Undefended. The suit is undefended.
Suit is undefended. So that is plaintiff witness number 1.
Lordship?
This plaintiff witness number 1 is present?
Yes, yes.
Okay.
It was continuing for some time.
He was examined.
He was examined. I'm just continuing marking exhibits and all that is going on.
So that can be done. আচ্ছা, এটা করা যাবে তো এখন? Yes, put it.
Just some more, Your Lordship. Maybe we can continue after that. I can complete a few ones today.
So only the documents are required to be exhibited.
Yes.
ঠিক আছে, তাহলে ইয়ে করে দিন।
Probably the officer needs to be called, Your Lordship.
Yes, yes, yes.
Just a digression, Your Lordship. I thought I'll mention that matter which was being heard with Honorable Justice Shobhushachi Bhattacharya and Lordship was sitting at that.
No, Justice I.P. Mukherjee.
2 cases, yes, 2 wills.
Justice I.P.
Yes.
Mukherjee.
A very interesting case that has been disposed of, Your Lordship.
Appellate side matter.
Yes, and we have.
Honorable Bhattacharya's matter.
Yes, we have won that, Your Lordship, and very interesting.
In
case.
appeal?
Yes, in appeal. The second will we got it probated.
Okay.
I remember Your Lordship was very well putting questions to me, and
I think that was a part heard also, but after Justice Mukherjee's
yes,
elevation, that
yes.
could not be taken up. Yes, এটা দেখি brief করি। This is a suit for? This is a suit for?
Yes, this is a suit on the basis of possessory rights. He's claiming money and compensation, Your Lordship.
এটা কত পজিশনসটা কোথায় আছে লাস্ট ডিপোজিশনসটা?
আগে হয়েছে হ্যাঁ তাহলে ওঠ ডকুমেন্ট সাবমিট করবে তবু ওঠ
So last deposition was on 25th, that is 16 December 2024, adjourned to 20th January 2025. There on 20th January deposition took place.
No, there was, he was not well, so it was again to another day.
এটার একটা এটা
May I put the
Yes.
question? I'm showing you this document. Please tell my lord what this document is about. This is an original.
এক্সিবিট মার্ক করতে পারবি তো
notice sent to your father Govinda Ghosh. Father, who appears on 22nd November 2025 for hearing at 12:30 p.m. regarding premises number 38.
M তো এখানে নেই।
Ward number 63.
একবার একটু জিজ্ঞেস করতে এক্সিবিট স্ট্যাম্প আছে কিনা
60.16.
পেনে করতে পারে। I'll speak to him.
Yes, that notice is tendered to him, that municipal authorities
Oh,
notice.
জানাতে বলুন, হ্যাঁ রিপোর্টটা হ্যাঁ না এটা উল্টো দিকে এখানে আছে না ওটা বলি প্লিজ সি ওভারলি and tell my lord what noting is there.
My lord, address to my father regarding the premises of
That has gone, I think. That is already recorded regarding the notice.
Yeah, yes,
Contents of the
but
notice.
there is a noting overleaf, so I'm just asking what that noting is. It's just his name, that's all.
Whose name? His father.
Govinda Ghosh, father's name.
hearing.
This may be marked as exhibit M, it will be, last one was L.
Last one was
L.
Exhibit L by 1.
Yes, so this will be M.
L by 1. It's
M.
not on. Huh? It is here L by 1. L by 1 means signature.
That was signature. Here there is no signature, so entire document can be marked
Entire
as M.
documents, okay.
Yes,
M, M.
M. I'm showing you another document. Tell my lord what this document is about.
Another notice sent by the Kolkata Municipal Corporation Building Department to my father, Govinda, on 30th May 2005.
এটা মিলে গেছে, হ্যাঁ।
This notice directing my father
এটাও entire document.
appeared before the special officer on 27th May 2005 regarding the construction of the building at premises number 30F Mirza Galim Street, Kolkata 16.
Yes, that's all.
Yes,
Next.
this may be marked as
Yes.
O. Sorry. It's being by N.
N.
Showing you another document. Tell my lord what this document is.
Because this is another notice sent by the Kolkata Municipal Corporation Building Department on 19th of August 2005 to my father, Govinda Ghosh, the plaintiff in this case. Again, asking my father to appear before the special officer building department for hearing. After the month of September 25, the notice asked my father to appear for hearing.
September date.
Saturday,
Okay, September 2000.
2005. My lord, this notice was sent to my father on 19th August 2005. 19th of August 2005.
To be marked Exhibit O. Yes. I'm showing you this document in original. Please tell my lord what this document is.
My lord, sent by the Kolkata Municipal Corporation, Masonry Building Department, Masonry Building Department. Addressed to my father, Govindu, having premises number 38, it's a college street. Ward number 63. On 5th October 2004. This is a report submitted by the surveyor of the Kolkata Municipal Corporation regarding the construction of a multi-story and multi-story building structure with RCC looking on premises number 30 and Street, Kolkata 60. For the purpose of running a guest house.
So inspection report dated 11th May 2005.
Prepared by the district building surveyor of 11 A. But it was detected on.
No, what it was the date of the report. That is what. That is what is appearing in the document.
Yes, sir.
Wait. This may be marked as P. Exhibit P.
LMN.
Last one was O. This is P.
P.
This is whole bunch of documents, Your Lordship. I was thinking if there is any procedure to curtail the process, but I'll go on individually.
How many documents you want to exhibit?
Another 20.
20. See, as much as you can today.
Yes.
Because
There is
after
no-
he's exhibiting the documents, nothing will be left out.
Yes.
Because whatever examination is there, you have done. Only this exhibiting of the documents. This is an undefended suit.
Undefended.
In undefended suit, cross-examination is permitted.
Yes, but nobody is there, so.
Nobody is there.
I was just wondering, loud thinking, if any way of curtailing this process.
Time is there. You try
A
to,
paucity of time, Lordship.
no, time is there. You
Okay.
try to
I'll
complete
continue.
it.
Yes. I'm showing you another document in original. Please tell my lord what this document is about.
My lord, this is a notice sent by the Kolkata Municipal Corporation to my father, the plaintiff in this case, on 7th of May 2005. Borrow number 7, word number 63. Asking my father that he had constructed a partly two-story and partly three-story structure with asbestos and RCC roofing, and even adjoining is another single-story structure was being constructed. Asking my father to demolish the structure and that adjoining structure not as per the Kolkata Municipal Corporation plan. This was given by the agency of Kolkata Corporation. Borrow number 7. May
This may be marked as Exhibit Q. I'm showing you another document. Please tell my lord what this document is about.
This is a letter sent by the Kolkata Municipal Corporation Building Department to my father, the plaintiff in this case, regarding premises number 38 Gully Street, Kolkata 70 17. This letter has asked my father that as per order of special building department dated 9th September 2005, a joint inspection will be held on 28th September 2005, along with the Department of Health and Fire Services, Complement and Fire Services Authority, and Fire Services at 12:30 p.m. at the caption premise. So the municipal authorities requested my father to be present at the site on that date and time. Letter was sent by the Kolkata Municipal Corporation on 21st September 2005.
Let it be marked Exhibit R.
R. Showing you another document. Please tell my lord what this document.
My lord, this is a money receipt given my father, Govindu, by the Kolkata Municipal Corporation Building Department on 7th April 2007 regarding the premises number 38 Gully Street, in respect of receiving guard posting charges an amount of 20,000 from my father. This money receipt dated 7th April 2007.
This may be marked as S exhibit.
Yes.
I'm showing you another document. Please tell my lord what is the document.
My lord, this is a calculation of detention charges for unauthorized construction as per order of the Special Officer Building Department and as per demolition sketch plan by the Kolkata Municipal Corporation. Demolition case number B by case number 296 hyphen B by 2054 407. Remittent number 38 in the current state. The total amount of retention charges for unauthorized construction as per the calculation of the this document was prepared by by the authorities of the
This may be marked as exhibit T. I'm showing you another document. Please tell my lord what this document is about.
My lord, this is the money receipt issued by the Kolkata Municipal Corporation, the City Architects Department, to my father, the plaintiff in this case, on 26 July 2004. Regarding the payment of a sum of 15,206 as per order of the demolition case that I have mentioned.
As per,
Order of the document that I have.
be specific, as per what? What is there in the document?
With that case number.
Okay.
And that can be
Now get the refer. You may just read out what is mentioned.
Yes, what
in
is there in the document, you
Not
just
refer to
read
any
out.
other document. Just
Yes, give the number.
Sketch B for unauthorized construction. Sketch B. Along with sanction fee and statute fee. Wastewater charges.
this may be marked as exhibit U.
Is PQ or
U.
U, right, because T has crossed.
Yes. I'm showing you one more document in original. Please tell my lord what this is about.
By the City Architects Department, dated 29 July 2004. Issued to my father. The plaintiff case in respect of premises number 30 the College Street. A sum of rupees 39,600 was paid by posting charges to the Kolkata Municipal Corporation.
Amount is paid to your father or paid by your father? By your father, yes.
To the Kolkata Municipal Corporation. Paid by my father.
By.
Kolkata Municipal Corporation. On 29 July 2000.
Exhibit B. I'm showing you this document in original. Tell my lord what this is about.
Now, this is a letter given by my father to the assistant engineer, Borough 7, Kolkata Municipal Corporation, on 26 July 2004. This letter is a prayer for withdrawal of municipal guard watch from guard watch WATCH on premises number 38 Mr. Gali Street, Kolkata 16, 16, ward number 63, Borough 7. This letter is a request from my father, the assistant engineer, withdraw the municipal guard watch from the above premises, and an assurance that my father shall not do any construction without any further permission from the assistant engineer.
Can you identify the signature at the bottom?
Yes, ma'am. I can identify.
You can encircle that in blue.
So the signature be marked V1.
Yes, that will be marked W1.
W1.
Yes. And this may be marked as exhibit W. Lordship, if we may pause here for the day, and if any date could be fixed, possibly 28th, 29th, if I may suggest, Your Lordship.
Okay. An order. Mr. Gupta, learned counsel for the plaintiff is present. PW plaintiff witness number 1, Sri Govinda Ghosh is present in court. Govinda Ghosh present in court. Plaintiff witness number 1 is further examined in chief.
He is not Govinda Ghosh, he is his son Budhaditya Ghosh.
Oh, this cause title it is showing Govinda Ghosh.
Yes, he is the plaintiff.
Oh, his son.
His son.
Okay. This is PW1. Okay. Govinda Ghosh na Budhaditya Ghosh is present in court. Plaintiff witness number 1 is further examined in chief and further examined in chief in part and discharged. Documents filed be marked exhibit L, exhibit M N. ওটা তাহলে স্পেসিফিক্যালি বসিয়ে দিতে হবে M2 L1 L1 যা যা আছে স্পেসিফিক্যালি
We did till W1.
M2 W1 On the prayer of learned Mr. Gupta, learned counsel for the plaintiff, further examination in chief is deferred till 30th or 29th.
28th, 29th, Monday, Tuesday, any day.
Deferred till 29/4/2025. Let this.
Would it be possible, Sir, Your Lordship, at 2 o'clock or then?
Let this matter be fixed at 3 p.m. 29th at 3 p.m.
Obliged.
আরেকটা আছে, হ্যাঁ, কল করে দিন। Okay, not today. Yes, Mr. Van.
Hello, I am for the defendant, my lord. Witness action, my lord will fix the date. My witness has not come today, my lord.
It is fixed for examination of your witness.
Yes, Your Lordship.
Any date, money suit. It's a simple money suit.
Yes.
May in the month of May, any.
Could you kindly give the short date, Your Lordship? I appear on behalf of the plaintiff, Your Lordship. Kindly give the short date.
Advocate for the plaintiff and
Project time.
advocate for the. You are for the sole defendant.
I am for the all defendants.
Advocate for the
5 defendants.
For the defendants.
All defendants.
Present. Mr. Banerjee, learned advocate for the defendants, prays for time as his witness has not turned up. As the witness has not turned up, such prayer is allowed. Let this matter appear on 1st of May.
My lord,
Great.
1st of May. 1st of May কি থাকে না একটা?
May Day.
May Day and something happens.
That holiday is continue.
No.
Anyway,
my lord, any 6 May.
Great.
6 May.
Great.
Because there's a problem.
Item 61, yes.
I am for the plaintiff. This is an undefended suit, my lord. The witness is over, my lord.
Yes, it's
Completed.
over.
Yes, let it be fixed for argument.
Okay, evidence of the plaintiff is over.
Over, my lord.
So let it be fixed for arguments.
Argument.
Record and order. Learned advocate for the plaintiff is present. It is submitted by the learned advocate that evidence of the plaintiff witnesses are over. Thus, the case be fixed for arguments on 7/5/2025. এটা 61টা, যেটা লাস্ট হলো 61তে অর্ডার হলো। হ্যাঁ, এবারে ফ্রেমিং অফ হচ্ছে। হ্যাঁ, দেখা যাক যদি ওল্ড সুট ফ্রেমিং অফ ইস্যুসটা হয়ে গেলে ওল্ড সুটটা আর একবার ডেকে দিতে হবে।
Lord, I am for the plaintiff, my lord.
I am for the defendant, my lord.
The last occasion, the direction was made for the filing of affidavit of documents along with the discovery and inspection. I am filing my affidavit of documents, but I need more time to discover inspection. my lord.
Therefore,
Plaintiff. I am for the plaintiff.
you are filing affidavit of documents.
Yes, my lord.
Service to the
I am giving.
You require time to give them inspection.
Yes, ma'am. Yes, my lord. It will take
But,
time.
Discovery of my lord documents and my lord inspection, my lord, your lordship can my lord direct, my lord, we can complete it within the meantime and my lord come back, my lord, before your lordship for framing of issues.
It's not complete
Actually,
yet, my lord.
it will take time, my lord, and that's why I am paying time and actually the haphazard everything.
Yes, record and order.
And a
Learned
copy the
advocate for the,
defendant.
it is sole plaintiff,
Sole plaintiff.
sole defendant.
Yes.
Sole plaintiff.
And learned advocate for the defendant are present. Affidavit of documents filed by learned advocate for the plaintiff be kept with the record. Copy be served upon the defendant. Learned advocate for the plaintiff 6 time to complete, to give inspection of the documents to the defendant. Such prayer is allowed. Let the inspection be allowed by 1st May 2025.
But some more time will
Some
be
more time,
required, my
my
lord.
lord.
I'll tell you, lordship, my lord, my client is, my lord, not from here. It's, my lord,
Actually-
suit for damages, my lord, where, my lord, my client is, my lord, based in Mumbai. So, my lord,
Let
I have to also obtain some documents, my lord. I will
let the inspection be given by,
my lord, discovery inspection in respect of both the parties, my lord.
let the discovery and inspection by both the parties be completed by 15/5,
15/5, my lord.
15/5, 2025.
I'm grateful.
Let the
Matter after vacation, my lord. Kindly give it an after vacation. That is
let
will
the
be better.
matter appear after vacation,
After vacation.
or liberty to mention after
Yes,
vacation.
yes, my lord. That will be better.
Okay, liberty to mention
Liberty
after
to
vacation.
mention. Yes, yes, my lord.
It's for the plaintiff, my lord. He will know it.
No, yes.
Okay.
Great.
These. Copy these.
Lordship, I appear on behalf of the plaintiff. Your Lordship, I was praying to extend the time to finish the discovery and inspection. Your Lordship, the inspection has not been done.
Documents are filed.
Twice orders were passed, discovery and inspection of documents.
Once the order was passed,
Not been
once,
done,
Your
my
Lordship, and the order has been passed once. We shall file our affidavit of
Documents not yet
not filed.
We
Your
have not,
Lordship.
my lord, done. My lord, let it be done within 30th May and the liberty to mention.
Yes, Your
Because they are
Lordship.
not doing so.
Your Lordship, we
Despite of
shall
twice orders,
provide
let
no,
it,
only
let
once
it
the
be done
order
with
has been
30th
passed.
May and liberty to mention.
Learned advocate for the plaintiff and learned advocate for the defendant are present. Learned advocate for the plaintiff prays for time to file the affidavit of documents. The prayer is allowed. The time to file affidavit of documents is extended.
And inspection. And inspection and discovery. And,
To conduct discovery and inspection.
because discovery and inspection, they have to come and see my
Actually,
document.
after filing of the affidavit, the date is given.
My
So
lord.
let them file on 30th. Thereafter, I shall give.
My lord, my lord.
Let the affidavit of documents be filed by 30/4/2025. 30th of April.
Lordship kindly gives us.
30th May she is asking.
It's an old suit. Lordship, any date in May, Your Lordship. Second week of May, any date.
30th May they will file and let the matter come after.
May is a holiday.
Oh,
Holiday, Your Lordship,
23rd, before
it's a
23rd.
vacation, but-
By 23rd May, last day of vacation.
Shall I make it 21st of May?
21st.
Yes, Your Lordship.
21/5/2025. Let this matter appear on 22nd. Anyway, on the same date. It will let this matter
21st.
21/5/2025.
My lord.
Grateful.
64th same order, my lord.
Similar order be
Similar-
passed, Your Lordship, in 64.
My lord, this is my suit, a suit for eviction of menial servants of a Shevaite's property. They are continuously delaying the matter. Suit filed 2012, issues were directed to be framed and submitted to the court in 2024. Now, after 12 years, they have filed an application for discovery of documents. That is the application which is appearing. So this is liable to be dismissed, but
GS6.
GS6 after 12 years in
The application
2025.
of the defendant.
Defendant for discovery, long over.
No, that is that application is filed in 2025.
After 12 years, they are filing.
Let it be allowed with heavy costs.
No, I have to file affidavit. Should dismiss. No reason.
You have not filed.
No.
Yes, record an order.
I am ready with my issues. Issues were directed. There's already an order dated 13 December.
So you have filed your affidavit of documents.
Everything is over. The learned judge, they filed an application for dismissal. That under Order 7 Rule 11, that is rejected. Continuously filing application to delay. They are menial servants staying in the Shebite property for years
Anyway,
without
not appearing also today.
without any.
Not an advocate for the plaintiff, whose opposite party is present. Yes, for defendant petitioner.
I want to file use an affidavit. This is
As
application should be
learned
dismissed.
advocate for the plaintiff opposite party, prays for leave to file affidavit to GA6 of 2025. Such prayer is allowed. Let affidavit in opposition be filed by 29/4/2025. Reply.
I give my lord some time because my client is not here. It will be two weeks.
5/5/2025. Reply, if any, by 8/5/2025. Let this matter appear on 13/5/2025.
Item number 66, Raigod Jute Mill.
My application, my suit, my lord, for eviction, your lordship.
Is actually
My lord,
on his
only
legs, my
one thing, your lordship, the issues have been already framed. If my lord kindly takes this order.
Issues are already framed.
Yes, your lordship. My lord, pursuant to order passed on 3rd December 2024, my lord, the issues have already been framed, your lordship. So I would be praying that your lordship will kindly fix this matter for witness action. Now, one thing your lordship will kindly take the order, Mr. Mitro, Honorable Justice Mr. Mitro was appearing when he was on this side of the bench. So we need to engage a senior in this matter. So my lord, 2 weeks time will be sufficient. So my lord will kindly give me 2 weeks time so that I can come with the evidence, affidavit and evidence, and the witness action may commence.
Yes, record an order. Learned advocate for the plaintiff and learned advocate for the defendant are present. As issues are already framed by order dated 3rd December 2024, let the matter be fixed for witness action on. Yes, when can you come? Ready?
My lord, any day on the in May or June, any day.
Month of May.
May, June में छुट्टी पड़ जाती है. My lord, in June, my lord, will kindly give them.
Okay, 10/6/2025.
10/6. I am grateful, my lord. But I will kindly fix a time, your lordship.
Actually, let the evidence commence. Okay, if the evidence commences and partly examined also, definitely I'll fix the time.
I'm grateful, my lord. I'm grateful.
Yes, take this. Yes, call the old suits.
Old suits, second call, item number 17, Devi Rani Nundi.
Not today.
Item number 18, Tascan Engineering. 19, Shambhunath Nundi. 20, Rakha Hari Sarkar. 21, Bilaspur Casting. 22, Prabhi Chaudhuri. 23, Jitendra Umabhari Patel. 24, Srimati Jharna Malik. 25, Ranjit Kumar Das, alias R.K. Das. 26, Graphite India. 27, Vishwanath Kalnoria. 28, Anubha Pal. 29, National Insurance Company Limited. 30, Somnath Estates Private Limited. 31, Unisilk. 32, Unisilk Limited. 33, Ashok Kumar Sen. 34, Rajnish Tiwari. 35, United India Insurance. 36, Deep Narayan Mitra. 37, Amit Basu. 38, StarTech International Limited. 39, Polar Fans. 40, Rashtriya Ispat Nigam. 41, Rashtriya Ispat Nigam. 42, Kumari Moon Roy.
To appear on behalf of the plaintiff, my lord.
You are
42.
appearing for the
Plaintiff, my lord, this is an uncontested suit. Paper publication was done. This didn't appear. My lord, on the last occasion.
Witness section কবে আসবে?
The suit of 2008.
Yes, my lord. Seriously. Now, may I give the short brief history of the matter? I initially filed a suit praying for declaration of my right as the legal heirs of my father. Me and my mother filed a suit in Shialda. That suit was transferred here. The defendant, who claimed to be the wife of my father, filed a counterclaim, but the entire transfer was not known.
It is a resident of this West Bengal.
Yes. Now, in the meantime, they file a counterclaim. The entire order of transfer and pendency of the suit here was not known to me. They file a counterclaim which goes uncontested, and my plaint went uncontroverted. They got a decree. I immediately file an application which was GA5 for setting aside that ex parte decree, which was allowed. On 3rd of January last year, it was allowed. Now, there was a counterclaim by the defendant which was uncontested. I filed an application praying for leave to file written statement against that counterclaim. Now, leave, my lord, kindly sees the last order of 2nd of September 2024. My lord, Justice Pottonayak was pleased to grant 90 days time to file my written statement.
Witness section.
Now, my lord, in the meantime, 2 vacations convened and there was a delay of 30 days.
Now, I am to hear this QOS 3 of 2008.
My lord.
This is to be heard.
My lord.
And so far this suit is concerned, it is the written statements have already been filed.
No, written statement was filed. My lord, I was granted a leave by Justice Rao. My lord, the written statement will be probably with the record to file the written statement on 22nd of January this year.
This is your suit, EOS 3.
My suit, there was a counterclaim.
In this particular
in
suit.
this suit,
Yes.
where I'm intended to file a written statement, which was leave was granted on September.
Yes.
Now, my written statement was due to be filed within 90 days.
Yes.
Now, I filed it on 22nd of January 2025 because I was under the impression
How many days delay?
if we count the holidays, there's no delay. If we count
No.
30 days, 30 days. 30 days delay, but leave was granted to file by Justice Rao. My lord, leave was granted to file on 22nd of January. That has to be regularized, accepted. The written.
The order of Justice Rao.
This is the leave granted by Justice Rao. This is my copy. The department, I have filed the written statement in the department. This is my copy. Another written statement. The plaintiff counterclaim written statement. This was the leave.
Okay, it was affirmed on 22nd January.
Now, I'm only praying so that my written statement be accepted and the suit may be proceeded with. That much I'm praying, my lord.
And the leave of, as per the leave of Justice Rao, you have to file within 22nd of January.
I have filed on 22nd of January.
You have already filed.
I have already filed on the self-same date. Since the department was not taking my written statement, there's a delay. But since Justice Rao has granted me leave to file, I have filed it in the department. Let that be tagged with the original file and let it be accepted, my lord. That's all I'm praying.
Learned, take down. Learned advocate for the plaintiff is present. None appears for the defendant. The second call.
It's a uncontested suit. I have done
Counterclaim is concerned.
No, I have done Order 5 Rule 20. Initially, there was a counterclaim.
Yes.
Suit decreed.
Yes.
I file an application for setting aside the ex parte decree. During pendency of that application, since they were not appearing, I was directed to take out an application under Order 5 Rule 20, substituted service. I did. The paper publication was done. Subject to satisfaction, since they did not appear, the court allowed the suit to proceed. That application, ex parte, those orders are there, my lord.
Learned advocate for the plaintiff is present. It appears that written statement to the counterclaim is filed by the plaintiff by 22nd January 2025 as per direction of this court. Let the written statement be put up along with this record for hearing of this suit. let this matter appear on 29/4/2025.
For further orders, my lord,
For
and,
further order.
and formal order of acceptance of my written statement I'm seeking.
Written statement filed in the department is accepted.
I'm grateful, my lord.
I mean the court of
Note কেটে দিন, note কেটে দিন।
oh,
Written statement filed to the counterclaim is accepted.
I'm grateful, my lord.
easy. Okay, দিয়ে দে। Item number 43. Item number 43, Garden Reach Shipbuilders. Item number 44, 44, Shomir Banerjee. 45, Rashtriya Ispat Nigam. 46, Sharda James Limited. 47, Nawal Kishore Choudhury and another. 48, Anjana Kharkia.
For the plaintiff. 48 for the plaintiff.
For the defendants. my lord.
Now, my lord, on 6th March 2025, my lord, an order was passed in their presence at their request, where, my lord, for last 2 years, their witness is to come to court and depose. So adjournments have been sought for on many years. May I, my lord, make such submissions, my lord?
For the plaintiff.
I'm for the
But
plaintiff.
this is
My
the order
evidence
your
is
lordship
complete.
had passed, my lord, once.
Now, my lord, may I indicate? They had, after completion of my evidence, they had filed an application for rejection of plaint on the ground of jurisdiction. That
Lordship has
application
heard
was
that matter.
dismissed. Then, up in appeal, at that point of time, my lord was sitting with Justice Mukherjee. But, my lord, when the appeal was ultimately dismissed, lordship was not part of that bench. So, lordship had not really expressed lordship. I am carrying the order.
So whether I
The
can
final.
take up this matter or not.
Lordship can, because lordship had not passed any order on merits. This is the final order. That was, my lord, there are many orders passed in the appeal. Every day matter was to be called and not heard ultimately. One, it was heard. Lordship was not.
Any
no, no.
fine disposal order passed?
Yes,
No,
by some other bench.
but not by me.
Not by my lord. That's my contention. I'm handing over the order by which the appeal was dismissed. My lord, so this is, my lord, another ploy of wasting further time of the
course
court.
not. What is
Otherwise,
my
this submission should not have
submitting?
been
I am
made in the first
I'm not
place.
even submitting that it's a ploy.
Then why are you submitting this?
I'm not submitting. I'm just handing over a copy of the order.
So, my lord, final order is there.
The question is regarding this bench taking up this matter. Do you have any
No,
objection?
my lord. Of course not. Of course.
So,
Goes
if
without
that,
saying.
kindly record this. Then that's for first, my lord. Second is
Your lordship, I need not record this, my lord. Your lordship can of course
tomorrow, my
take up
lord.
this matter.
Today, my learned senior friend is there. Tomorrow, some other lawyer will come, and I do not know what submission will be made. I can trust him, but I don't trust every other lawyer here. But on 6th of March 2025, well, kindly, if lordship takes that order, my lord, on the last time notice,
The appeal against that
that
dismissal of-
dismissed.
But I'll
Appeal is
tell
also
you, lordship,
dismissed.
what happened was
Then
initially,
they
my
preferred
lord,
a Supreme Court
initially, my lord, I
SLP.
filed an application for revocation of leave under clause 12. My lord, that application was dismissed, and my lord, we preferred an appeal from there. My lord, the appeal was heard by your lordship and Honorable Justice Mukherjee, my lord, sitting in division bench.
the month of September 2024.
Not hard. Lordship were there on the first day. Matter was hard by another day. Yes.
On the date of
Yes.
admission. But the final order, which my lord, your lordship, my lord, where the appeal was disposed of, your lordship was perhaps my lord, not my lord, part of my lord, the division bench of this.
Now a long period have passed. 6
Long
months
period
have
has
passed.
Yes.
So witness action have not yet started.
No.
My lord, because my lord, the plaintiffs were the defendants witness, my lord, was my lord suffering from heart ailments. My lord, I have my lord produced documents before my lord the lordship's
There have been
predecessor.
appointment of a commissioner. That
Yes.
has been done.
That was, and the other one, he himself said that he will bring this hand.
Even if you want, I can also appoint a commissioner.
Right now, I'm giving consent.
My lord, 2 weeks time.
Kindly
Let
do
me
not-
get my
this is
house in
going
order.
without-
Well, I'll tell you, lordship.
But this
Let
is
me
not
get my
kindly appreciate.
Comfortably he can depose.
From his
I'll tell you,
home,
lordship.
virtually, I have no problem.
Well, I'll tell you, lordship. My lord, commission also in my lord has some
This
cost
witnesses
implications.
should not be done virtually.
I know, but if he
Absolutely.
Either in
witnesses,
court or
Or through
I know.
commission.
I am ready and willing to every suggestion he makes. If there's a, he has to
There's
make a
a cost
suggestion.
implication also, my lord, in commission. So, my lord, that is also what we have venturing through. And my lord, if possible, my lord, kindly gives us 2 weeks, my lord, as a final opportunity, my lord, we
Kindly,
shall, my lord, come back before your
kindly take
lordship.
your 6 March order, my lord. Kindly take. That was the 4th attempt. 6 March, my lord. 6 March. I'm handing over a copy. 6 March order, my lord. This is the probably 10th time my learned friend making the same submissions of ailment. Kindly see the order and what was his.
if there is a
But then
submission of
these
ailment,
next
then
today.
the commissioner has
Today is
to
the 10th next day.
My
my lord.
learned friend
Every
cannot,
day I
my lord,
come
take
and I
eyewitness from his home and my lord, let him, my lord,
Where
deposit
does
in
your
the.
client reside?
My lord, he's from
Baliganj.
based in Kolkata.
Baliganj.
Based in Kolkata.
The commissioner can be appointed. It
Easily,
will not be
Milord.
very costly.
Well, I'll tell you, Lordship, the
Kindly,
difficulty
since
is
the order
that
dated 6 March, I am requesting your Lordship, kindly allow me to read this order, Milord. Mr. Shankorson Shoka, my learned senior friend, for the defendant number 1 submits that the witness Ashok Kumar Kharkia, defendant number 2, is suffering from heart ailments and has been advised not to move without medical assistance. He further submits that some more time will be necessary, within which period the defendant can decide either to examine the witness defendant number 2 by way of a commission or take steps to examine the son of defendant number 2, Ravi Kharkia. He seeks accommodation for 2 weeks. 2 weeks. Now, Milord, after it's more than a month. Now, Milord, kindly take 6 December order. Order prior to that. Same submission. 2 weeks.
all the time.
Every time they come,
all
they
the
say
time.
heart ailment, give me 2 weeks. We come back after a month.
Best I can give them 3 weeks. Okay.
But if Lordship gives them 3, Lordship gives them further.
Special opportunity. Otherwise, you see, you have to bear the commissioner's cost.
But kindly, Milord, let the son come. Ravi Kharkia, their own submission. Either the father.
Better to examine the person.
I have no problem in examining anyone, but kindly, Milord, bring it to an end.
The learned advocate for the plaintiff and learned advocate for the defendant are present. Learned advocate for the defendant prays for time as because his client has not recovered from the ailments.
Let him submit the medical
The
documents.
interest of justice. 3 weeks time is granted to the defendant to take necessary instructions, either the defendant should come to court or necessary application for necessary order for appointment of commissioner has to be made. Let this matter appear on 13/5/2020.
I have only one request, Milord. My client is also present. I have to make this request, Milord. Since, Milord, every day I've shown Lordship 3 orders. Every day, same prayer, same submission, and adjournments have been taken. Only one request, Milord. If kindly record it, I am not seeking any. Kindly record that if they don't bring any evidence on the witness on that day, or Milord do not agree to go for commission, the evidence of that witness.
Are you willing to share the cost of the commission?
Yes.
Yes, we are
I am ready to do everything that Milord takes
I
to.
shall consider on the next day.
But look, only record that his evidence should be closed. Otherwise, this person, Milord.
Another thing is this, you see, in court, sometimes for ailing persons, cannot compel to go on deposit. It takes long time, this examination and cross-examination. So this commission is better.
It is better always that they are talking about health ailments, but they went to Supreme Court and filed SLP. The same person.
Even no instructions is taken, necessary orders will be passed on 13/5/2025.
For closure of evidence of that person, they bring another witness.
Whatever orders, okay.
But otherwise, not next day again, Lordship can see from orders. Every day they are coming. That's a request.
There will be 2 options. Either it will be closed,
yes,
or they have to accept appointment of commission.
Yes.
There cannot be any other third alternative.
That may also be recorded.
On one last thing, let it be recorded that there is no objection regarding the determination, Milord. Kindly that be recorded. I can trust my learned senior friend, but I do not trust him.
Kindly do not make it part of the order.
No, Milord. Unnecessarily the order was shown, so Milord, I have to.
The plaintiff and learned
By consent of the parties, matter is taken up.
Learned advocates refer to an order of the Honorable Division Bench in the matter of
4th September.
in APOT 67 of 2024, in which I was a member, and submits that as the disposal order was not passed by the bench in which I was a member, the learned advocates have no objection in this bench taking up this matter.
Grateful.
Thus, this matter is taken up for consideration.
Grateful, Milord.
Grateful.
Item number 49. Mr. Srimurthy Cargo Movers. Item number 50. State Bank of India.
I appear for the defendant.
Your for?
The plaintiff.
I am for the defendant. No,
But,
this matter
in
was
this matter, a written statement has been filed by my learned friend. And let there be direction for cross order for discovery.
My lord, there was already an order
Nothing
of
has-
26 March.
Filed by the plaintiffs.
My lord, they have filed written statement, but after filing the written statement, Suit has not been progressed as yet.
Yes, let me see the last order.
And this is the last order, Lordship. In the last order, there was already a direction for discovery inspection. And
No,
and it was due to
discovery
appear on.
inspection, you see first affidavit of document.
And there was it was supposed to,
not filed.
and it was supposed to come up on 7th of May as well.
7th of May.
So it has come up
Shall
wrongly
I fix
today.
it on 7th of May? And you will file your affidavit of documents.
Well, let kindly give me more time because it is bank matter. Records are very old. On this day, I was not there.
Okay, record an order. Learned advocates for the parties are present. Learned advocate for the plaintiff press for time to file affidavit of documents. Such prayer is allowed. Let this matter appear on 21st of May.
Well,
21/5/2025 for filing affidavit of documents by the plaintiff.
have you filed?
যেটা appear না করে 7th of May there.
তো স্যার আপনার সুট আপনি দেখেন তো আগে
আচ্ছা
ফাইল করেনি।
7th of May তে যেটা appear করা the matter need not appear on 7th of May.
Direction has to be passed.
The 7th of May তে appear করা ছিল, আমি 21st of May করে দিলাম।
both sided হবে না?
হ্যাঁ সেটা
The matter did not appear on
রিটেন স্টেটমেন্ট দিয়েছি।
March. Now, ওটা বলে দিলাম, as because the matter is fixed on 21st May, the matter need not appear on 7th of May. 7th of May তে তো already আছে তো। আচ্ছা, as the matter is fixed on 21st May, এটা লিখে নিন একটু। As the matter is fixed on 21/5/2025, the matter need not be put up on 7th May 2025 as earlier directed.
Grateful.
I'm grateful.
কালকে যদি না অ্যাপিয়ার করে তাহলে নট দিস উইক করে দেবো, তারপরে যদি দেখা যাচ্ছে কেউ অ্যাপিয়ার না করে তখন দরকার হলে নেসেসারি অর্ডার পাস করতে হবে আর কি। না কিছু করছে আর কি, সবাই অনেকে করছে না, কিছু করছে আর কি। হ্যাঁ, দু একদিন যাক আর কি।